Good morning. Please keep your microphones muted during presentation. My name is Hayeon Jessie Ryu Allison, a research fellow at the Korea Institute for Maritime Strategy. Established in 1997, the Korea Institute for Maritime Strategy aims to identify and analyze some of the latest and most pressing issues related to the maritime domain, including maritime strategy, security, history, and law, in hopes of keeping both the government and general public informed. It is with this mind that today's invitation-only event was organized. It is now my pleasure to welcome everyone to the second Sailors Dialogue, the Law of the Sea and Law of Naval Warfare in Conflicts at Sea. The Sailors Dialogue is organized by the Korea Institute for Maritime Strategy to foster frank discussion and vibrant intellectual engagement on various aspects of maritime security. Its goal is to assist policymakers, in particular the Navy, Marine Corps, Coast Guard, and Foreign Ministry, tackle real-life questions they confront in their respective fields of expertise. Today, we're honored to have with us Professor James Kraska. To briefly introduce the speaker, Professor Kraska is a chair and Charles H. Stockton Professor of International Maritime Law at the Stockton Center for International Law at the U.S. Naval War College, the first established chair at the institution. He is a visiting professor of law and the John Harvey Gregory Lecturer on World Organization at Harvard Law School. He is also a visiting professor of law at the College of Law, University of Philippines, at the Gujarat National University in India, and a visiting scholar at Duke University. Professor Kraska has published numerous articles and several books, including publishing in Oxford University Press and Cambridge University Press. Please note that the presentation will be followed by a Q&A session. Please keep your microphones muted during the presentation. Please type your questions in the text box. With that, I will now turn over the floor to Professor Kraska. Professor Kraska, the floor is yours.
Thank you for the kind introduction, Dr. Ryu Ellison, and thank you to the Korea Institute of Maritime Strategy. It's wonderful to be back. The last time that I participated in a KIMS event was the 12th ISS in 2015, and so it's been some years, and I'm very glad to be with you. I also note for many of the Philippine officers that we have and that are joining us today that I'm also speaking at the Philippine Armed Forces College tomorrow on the South China Sea arbitration, just by coincidence. What I thought would be good today is if we talked about trying to devise the gray zone or understand what we mean by the gray zone and where this fits with the law of the sea and the law of naval warfare. So I'll go along those lines, and you're welcome to save your questions, or if you have a really burning desire, you even can raise your hand if I can catch it. Can everybody see my front slide okay? All right, so let's just talk about where this idea of the gray zone occurred or came about. This sense that we have a fusion of the peacetime law of the sea and the law of armed conflict, and at sea, that's the law of naval warfare. Just one or two fundamentals. First, both in peacetime and during armed conflict, warships and other government vessels that are, for the time being, used on non-commercial service, such as customs enforcement vessels or Coast Guard ships, even if they are not designated as warships, they have certain rights in the law of the sea. Principally, they have the right to enforce laws, both within a country's territorial sea or archipelagic waters, as well as crimes of universal jurisdiction beyond the territorial sea, such as piracy or slave trafficking. So these warships and other government vessels have this privileged right in peacetime to conduct maritime law enforcement. And that makes them distinct from commercial or non-governmental vessels that lack that right, that may not lawfully attempt to conduct maritime law enforcement. So we already see that in areas such as the Yellow Sea, the East China Sea, the South China Sea, where you have fishing militias that purport to be enforcing laws, those lie outside of the recognized legal structure. Warships also enjoy belligerent rights during armed conflict. That's different from other government vessels. So unless a Coast Guard vessel is designated as a warship, then it does not enjoy belligerent rights. That means that it may not engage in belligerent acts. These could be attacks against the enemy, or they might be something less, such as the right of visit and search to look for contraband during an armed conflict. So remember that this right only applies to warships. It does not even apply to naval auxiliaries or, say, customs vessels or other government vessels, such as maritime law enforcement vessels. Only warships enjoy this right. So we have to always distinguish between peacetime and armed conflict. And then toward the end of my discussion, we'll talk about how these came to be blurred and how we can think about them legally. So remember, in peacetime, there's an entire regime of warships that's reflected in the UN Convention on the Law of the Sea. And principally what this regime does is it recognizes that warships have certain enforcement rights, such as piracy that I mentioned, and also certain navigational rights in the territorial sea and on the high seas. And then significantly, warships are always entitled to sovereign immunity. Also, other government vessels that are on non-commercial service are entitled to sovereign immunity as well. Coast Guard vessels, maritime law enforcement vessels. Why do we have to emphasize that they are on non-commercial service? Because if a state has a warship and uses that warship or Coast Guard vessel for some sort of commercial enterprise, then that vessel loses its sovereign immunity. And sovereign immunity protects warships and other government vessels from assertion of jurisdiction by any other state of the criminal laws or the civil laws on that ship. Even if that Coast Guard vessel were in the internal waters of a foreign state, that foreign state may not legally assert jurisdiction over it for any purpose. In Article 236, that includes purposes for protection of the marine environment. So coastal states may not try to enforce their environmental laws against warships. And then finally, warships and other government vessels through sovereign immunity can be exempt from dispute resolution in the Law of the Sea Convention. All right, so we always want to distinguish between peace and war. In the law, there is no gray zone, okay? There is no gray zone in the law. There is only peacetime and armed conflict. Does everybody see like a red mark here? That's kind of strange. Do you guys see that? Give me a thumbs up if you see that. I don't know why that's there. Okay. Well, I'll just ignore it. But I see this red mark. I'm not sure what it is. Maybe something's wrong with my screen. I'm not sure because it doesn't show it on my side. Let's just pretend it's not there. All right, so always distinguish between peacetime and war. let me emphasize again, in international law, there is no such thing as a gray zone. There's no such thing as a gray zone. There's either the law of peace or the law of armed conflict. So in the law of peace, the law of the Sea Convention governs the usage of the oceans, where you can go, what you can do, and human rights law governs the use of force. That's in the law of peace. In the law of war, the law of the sea also has some role because it determines where belligerents can conduct lawful operations. Basically, law of naval warfare can be lawfully conducted anywhere outside of the territorial sea of neutral states, anywhere in the world. So if you have a country, let's say Argentina, and it's in a armed conflict with Iceland, those two states can conduct naval warfare anywhere in the world outside of the territorial sea of neutral states. Now, another distinction is that during armed conflict, the use of force is very different from peacetime. In armed conflict, the use of force is governed by the law of naval warfare, which is part of the law of armed conflict, and it permits status-based targeting. In the law of peace, force can be used under human rights principles when force is necessary and reasonable in the circumstances. But in armed conflict, force can be used targeting of lawful enemy combatants can be done at any time, regardless of their conduct or their behavior, merely based on their status. Okay, so let's take a little closer look at these. And let's see. If you don't mind, I'm going to reshare my screen and see if I can get rid of that red line. Okay, I think that's better, isn't it? All right. So let's look at the peacetime side, then we'll look at the armed conflict side, and then we'll compare the two. So maritime law enforcement is in the peacetime side, and this is the business of which many of the Coast Guard, Philippine Coast Guard officers and Korea Coast Guard officers that I saw that were in the list of participants tonight, this is your business. And you understand that when you conduct a visit, board, search, and seizure, that's just an operational concept, and that it involves potentially many different players. And you just never know what you might encounter, and that you have to accommodate possibly different flag states. You might have a Liberian vessel, and the vessel might be owned by a company in Hong Kong, and the cargo might be owned by a company in the Ukraine, and the crew on board the ship may come from Georgia and the Philippines and Sri Lanka, and the flag state of the maritime law enforcement or warships involved might be, let's say, the Philippines, and maybe some other country is nearby or involved that also has warships. And then if there's force that is used, such as in the case of piracy, those individuals also might have a different nationality. They might be Somali, or they could be Indonesian or some other country. And so this creates a complex Rubik's Cube of law enforcement. In the peacetime law of the sea, approach and visit may be conducted based on a variety of legal rationale. So you may board a vessel if you have the flag state consent. You can board the vessel if you have the consent of the master on board. This is the US perspective, and it's also the Royal Navy of the United Kingdom. Not all countries accept that, but generally there's the idea that the master of the ship has plenary authority over that ship and can authorize boarding of the vessel. Remember, under Article 110 of the Law of the Sea Convention, that any warships or government vessels of any nation can board stateless vessels. Also, under Article 110, boarding can be done based on unauthorized broadcasting, piracy, or slave trafficking. And then there are some additional bases for boarding foreign flagged vessels beyond the territorial sea, including protection of submarine cables, fisheries enforcement, and in some cases, even environmental protection. So we'll just cover these very quickly because I think that these are relatively well known, but I would like to put them in a legal context, both within the peacetime boarding process, as well as where that fits with armed conflict and how we get this gray zone that's so troublesome to us. Now, remember that maritime piracy is a lawful basis for boarding under Article 110, where a maritime law enforcement or warship has reasonable grounds for suspecting that the vessel is engaged in piracy. This authority is derived from or flows from first the 1958 High Seas Convention, in which all warships and maritime law enforcement ships may seize pirate ships or aircraft. And so this 1958 convention, the text in Article 19 is carried over into UNCLOS in Article 110, which says that if the government ship has reasonable grounds for suspecting that the ship is engaged in piracy, then it may board the vessel. Now, how do you form reasonable grounds? Well, you could have intelligence cueing, or you could just ask the ship over VHF, where are you going? What are you doing? What was your last port? What's your next port? What's the cargo that you have on board? What's the nationality of your crew? All of these questions are lawful under this right of approach in customary law. This right of approach is the right of, please, everybody, please mute your microphones if you would. The right of approach. Yeah, the right of approach in customary international law is derived from this case, the Mariana Flora. And this was a vessel that was approached by a warship, the USS Alligator, back in 1825. And the Alligator thought that the warship was actually the pirate ship. It was not. This case went to the Supreme Court because the Alligator fired on the Mariana Flora and damaged the ship. And the owner of the Mariana Flora said, wait, you just sort of attacked me. All I was doing was fleeing from you. But the Supreme Court said, sorry, you cannot flee from a maritime law enforcement vessel. If the vessel suspects that you're committing piracy, they may lawfully compel boarding of that ship. Now, slave trafficking is another rationale under Article 110 for boarding, and this also grew out of customary law. The British operated the West Africa Squadron in 1870 in order to suppress the transatlantic slave trade. And so Britain expanded this right of approach and visit from just including piracy to also including slave trafficking. And then that additional rationale for boarding a ship is also included in Article 110. Now, 110 of the Law of the Sea Convention also identifies unauthorized broadcasting as well as a basis for boarding, for the right of approach and visit, as well as assimilating a stateless vessel. And that's what happened when US and Spanish naval forces interdicted this motor vessel Sosan in 2002. Now, this was a North Korean operated vessel that claimed different or conflicting nationalities. And as a result, it was assimilated as a stateless vessel, and it was boarded by Spanish Marines, and it was found to be, it was not flying a flag at all, so it was the US and Spanish were unable to confirm registry, and when they boarded it, they found that it was carrying 15 Scud missiles that were concealed under bags of cement. And these Scud missiles were actually on their way to Yemen in order to fuel that civil war going on there. So if a ship is stateless or it's assimilated as stateless, it's also a basis for peacetime.
Yung sa sikat, kunin mo yung meeting ng sikat. Yung bukas.
Okay. So there's another basis for boarding a ship that most people don't talk about. And this is that under the 1884 Submarine Cables Treaty, that coastal states or any state can board a vessel if it's suspected of injuring or damaging a submarine cable. There's only one known instance where this has happened, and this was in 1959 when a US Navy ship boarded a Russian fishing vessel, the Novorossiysk, and this can be affected under Article 10 of the 1884 treaty. So be aware that if you have evidence that a vessel has cut or damaged submarine cables, that provides a lawful basis in peacetime for boarding. Now, another basis for boarding and even for use of force if necessary is enforcing EEZ rules against foreign fishers or fishers of any nation. Here, what we have are the Republic of Korea Coast Guard boarding Chinese fishing militia vessels in the Yellow Sea. And of course, they have a right to do so. You can see that they have on protective gear, and the Chinese vessels have lashed all together in order to make it more difficult for them to be boarded. Nonetheless, there's a right for South Korea to do so. And in this graphic here, you can see the men in black, the tactical team crossing over from ship to ship. And so this is peacetime. And that means that humanity, due process, and fairness or human rights law applies in this case, even though it might be state action on the part of another country. And that under fisheries rules in the Law of the Sea Convention, that the enforcing state must promptly release vessels that are detained upon the posting of a reasonable bond. And the bond is based on the value of the ship, as well as the value of the illegal cargo or the illegal fishing that was done in the EEZ. This rule on the use of force is also reflected in the High Seas Fish Stocks Agreement, which implements the Law of the Sea Convention. It's the second implementing convention for the Law of the Sea. And it says that fisheries enforcement may use that degree of force that's reasonably necessary in the circumstances. Reasonably necessary in the circumstances. Now, what about in the case of environmental enforcement during peacetime? Well, that gets a little more difficult because coastal states do have prescriptive jurisdiction to enforce the environmental laws in their EEZ, but under Article 220 of the Law of the Sea Convention, that authority is actually limited only to those instances in which there's actual or threat of major environmental damage. And even then, the coastal state can only adopt and enforce rules that are generally accepted, international rules. So this rule in peacetime that force has to be necessary and reasonable and necessary has emerged from several landmark cases, including the I'm Alone case, which involved U.S. Coast Guard cutters or U.S. revenue cutters against the ship I'm Alone, which was carrying illegal rum. It was a rum runner, and it was a British flag vessel, and U.S. forces boarded it, and they used force, and it went into an arbitration. And the arbitration determined that force can be used in peacetime for maritime law enforcement so long as it is necessary and reasonable under the circumstances. The other landmark case is the Red Crusader. The Red Crusader was a UK fishing trawler that was caught fishing in the Faroe Islands, and it also went into an arbitration, and it was determined that the use of force could be used, but it has to be necessary and reasonable. And in this case, force by Denmark was deemed to be excessive against the Red Crusader. And so in that case, the findings were that the firing on the ship exceeded the legitimate use of force on two counts. First of all, the Danish warship fired on this illegal fishing vessel using solid shot, and that created a danger to human life that was not necessary. And so this was a violation of the peacetime rules. Now, just as we finish the peacetime rules, it's helpful to note that they are also reflected in 1990 principles for the use of force, as well as this other very important case, the Motor Vessel Sayaga number 2, that says that this was a case where St. Vincent and the Grenadines operated a tanker that was providing fuel to illegal fishing boats off the coast of Guinea, and Guinea patrol vessel fired on it. And the Tribunal for the Law of the Sea said that force must be avoided, but when it is used, it has to be necessary and reasonable in the circumstances. In this case, like the Niels Ebsen with the Red Crusader case, the Motor Vessel Sayaga court determined that force was excessive because the Ghanaian law enforcement vessels fired indiscriminately once on board the ship, and they severely injured 2 people. All right, now as we go up through the conflict spectrum from things like fisheries enforcement or piracy and into terrorism, we get closer and closer to what might look like armed conflict. The only legal authority that we have to kind of bridge this gap in the use of force derives from this case of the Achille Lauro hijacking in 1985. So what happened is that 4 Palestinian terrorists boarded the Achille Lauro. You see here, they seized the ship in Port Said, Egypt, and then they took it to Syria. 4 terrorists took this cruise ship to Syria, and Syria denies entry. And that's when the terrorists killed an American Jewish passenger on board named Leon Klinghoffer. And then number 3, the Palestine Liberation Front said that they would surrender if they were taken to Cairo. And they had a deal with Egyptian President Mubarak that they would be flown to Tunis, to Tunisia in number 4. But what happened is in number 5 and 6, US fighter jet aircraft from an aircraft carrier intercepted the terrorists in the middle of the air and forced them to land at a US naval air station in Italy. And of course, this created a diplomatic fallout, but for our purposes, it led to first the 1988 and then the 2005 SUA Convention, SUA. That's the Convention on the Suppression of Unlawful Acts Against the Safety of Maritime Navigation. And the SUA Treaty, if it's in force among member states, also permits necessary and reasonable force, as well as not just for piracy, but also for terrorism or using a warship or using a vessel rather as a weapon, putting weapons of mass destruction on board a vessel, and other crimes. Now, the attack on the USS Cole in 2000 in Aden Harbor is a terrorist incident that almost sank this US capital warship. Similar to the Super Ferry 14 terrorism attack, where terrorists exercised force that was almost to the level of an armed conflict. Similarly, the seizure by North Korea of the US spy ship, the Pueblo, in international waters, also is an incident that sort of falls in with this gray zone. But the gray zone was relatively dormant during the Cold War because the potential impact for armed conflict between the superpowers was so great. Only with the resurgence of Russia and China in the recent era have we found new usage for this term gray zone. So this raises the question, for example, with regard to the Russian invasion of Crimea and what law applies in the Kerch Strait and in the Sea of Azov between Ukraine and Russian armed forces. Is this the peacetime law of the sea, or is this the law of naval warfare? A similar question might arise with regard to the sinking of the ROK Navy corvette, the Chonan, in 2010. This was a North Korean submarine that sank the South Korean Chonan, and there was no international action taken by the Security Council. The Security Council only issued a presidential statement that expressed deep concern. But a multinational evidentiary team, including the United States, Australia, Canada, Sweden, and South Korea, determined that this was in fact torpedoed by North Korea, and yet North Korea did not suffer any sort of sanctions. And they also violated the armistice between North Korea, South Korea, that is in effect with the UN United Nations Command. So this is another type or example of the gray zone, which leads us to wonder what law applies. Well, I'll tell you my view is that in the case of the Kerch Strait and Ukrainian warships and Russian warships, that this is understood usually to be a situation involving the law of the sea. I would suggest, though, that it's much closer to the law of naval warfare, because Common Article 2 of the Geneva Conventions says that the law of armed conflict applies to all cases of declared war or other armed conflict, even if a state of war is not recognized by one of them. Well, what about going back to the Chonan? What law applies. Does the peacetime law of the sea apply or the law of armed conflict? In this case, my view is that because it's a violation of the armistice, even though it's not a comprehensive peace treaty, armistices after World War II, after the advent of the UN Charter, are treated as freezing in time the status quo, and it is tantamount to a peace agreement. And this view is accepted by Yoram Dinstein and other scholars, and therefore this was a violation of peacetime rights. It was not a lawful attack during armed conflict because the conflict was permanently suspended by the armistice. So now let's get into the gray zone and how we apply both the law of the sea and the law of armed conflict. The first thing to understand is that the right of approach and visit that we talked about in peacetime is a different right from boarding ships during armed conflict. It's a different right. The law governing approach and visit, the case of the Mariana Flora, that governs all of those cases that we talked about in peacetime, from piracy to slave trafficking to boarding of a stateless vessel like the motor vessel Sosan, all of those peacetime authorities, that's an entirely different situation than during armed conflict or presaging armed conflict. Boarding a vessel during armed conflict is called the right of visit and search. So never mistake the two. Don't mistake the peacetime right of approach and visit with the wartime right of visit and search. The right of visit and search is very simple, whereas the peacetime right of approach and visit has all of these different rationale. It could be piracy, it could be even fishing violations, all those things we talked about. In visit and search during armed conflict, there's one basis for boarding a vessel, and you can board any foreign flagged merchant vessel, not warship or government ship, but merchant vessel. And you can do so to determine the enemy character of the ship or its cargo. The enemy character of the ship or its cargo, meaning, is this vessel providing aid to the enemy? Is it being used to carry goods, belligerent goods to the enemy? Or is it providing intelligence for the enemy? And you have an unmitigated right to board that ship. And if the ship does not submit to visit and search, you can attack it. You can attack the ship if it doesn't submit to visit and search. Okay. Now, we have all those bases for boarding during armed conflict, but what about the basis for boarding? What is a lawful trigger for the right of boarding for armed conflict? So there's peacetime boarding in armed conflict, and BBSS on the way to war can be justified through the UN Security Council, Chapter 7 authorization under Chapter 7, or through self-defense, or this belligerent right of visit and search that I just mentioned, if you're in an active armed conflict. So let's focus on the first two, UN Security Council or self-defense. Both of these derive from the UN Charter. These are lawful ways to use force in armed conflict, not law enforcement. We live in the Charter paradigm, and the Charter paradigm says that it is illegal to use force against another country, or it's illegal to threaten to use force, not just use force, but it's illegal to threaten to use force against another country. And if you do, then that may trigger the right of self-defense under Article 51 if there is an armed attack. If there is an armed attack. Now, the right of self-defense is triggered by an armed attack, but the rule is that states may not threaten or use force. So a threat of force is not an armed attack, and therefore it doesn't trigger the right of self-defense. Now, first of all, the UN Security Council can also authorize the use of force, but and they can do so if there's a threat to the peace, a breach of the peace, or an act of aggression. A threat to the peace is if the Security Council is proactive. A breach of the peace is if it's reactive, and an act of aggression would be some other action taken by the Security Council. The problem is this has only happened 2 times in history. The first is the Korean War. We're still living under the results of that. And the second is the Gulf War against Iraq. Okay. And on self-defense, when is self-defense authorized? Under the Caroline Doctrine, self-defense is authorized when the attack is imminent, or there is no choice of means or no moment of deliberation. This is derived from this Caroline ship that you see here that went over Niagara Falls. The vessel was aiding Canadian insurgents, and it was captured on Navy Island that you see here in orange in Canada. And there was an American group that was aiding these Canadian insurgents that wanted to join the United States, wanted Canada to join the United States. Anyway, it was somewhat of a debacle, and the Canadians captured the ship, and they sent it over. They lit it on fire and sent it over the Niagara Falls. But during the subsequent arbitration, the famous dictum was that force could only be used if there was a need that was instant, overwhelming, and leaving no time of deliberation or no choice of means. And this has worked its way into contemporary jurisprudence. There are 3 elements of defense, of self-defense. Under the Caroline Doctrine, the attack must be imminent, it must be necessary to respond, and the response must be proportional. In other words, if you have something like the Caroline, the injured country cannot use a nuclear bomb in order to respond. Now, what does this mean for the gray zone? We have a problem, and here's where the gray zone was created. Go back to Article 2.4, and it says that the threat or use of force is illegal. But then it says that self-defense can occur if there's an armed attack. So the language doesn't match up entirely. And in my view, that has been expanded by the International Court of Justice in 2 landmark cases. And I'll cover these cases and then we'll take questions. Okay. The cases are the US versus Nicaragua, and that's the paramilitary activities case. And the second, the 1986 case between the US and Nicaragua, and the second case is the US versus Iran, and that's the oil platforms case of 2003. And both of these cases, in my view, have muddied the water. They've actually made things worse, and they've actually contributed to this idea of a gray zone, or indeed even created the gray zone. They've even created the gray zone. How is that? Because the Nicaragua case involved United States supporting so-called freedom fighters in Nicaragua. These were anti-communist insurgents that were attempting to overthrow the Nicaraguan communist government that you see here. Why? Why were they doing this? Because Nicaragua was engaged in providing assistance to communist guerrillas in El Salvador and also Guatemala and Honduras, trying to destabilize its neighbors. And they had brought essentially a civil war into El Salvador, and they were also destabilizing Guatemala and Honduras. Justin Agcaoli, you have your hand raised? You have a question? Okay. So the United States, under President Reagan, said, well, look, if Nicaragua is going to fund communist insurgents in these neighboring states, then the United States is going to help them out. And at the same time, the US is going to fund what are called Contras, or counter-revolutionaries, against the Nicaraguan regime. And Nicaragua took the United States to the International Court of Justice. The United States had in addition to funding these counter-revolutionaries in Nicaragua, had also done things like mine the harbors of Nicaragua to prevent military aid from the Soviet Union from supporting the regime there, and trying to destabilize the Nicaraguan government as a way of self-defense, because Nicaragua was trying to destabilize or foment insurgencies in its neighbors. What did the ICJ say about this? The ICJ said the United States claim was that, look, everything the US is doing, it's doing in self-defense. And the ICJ did not agree with the US. It said that even if Nicaragua was attacking its neighbors or was funding communist insurgents in El Salvador, Guatemala, and Honduras, what Nicaragua was doing lacked gravity or lacked a scale and effect that was tantamount to a conventional war or a conventional invasion. And because even though Nicaragua was doing these things, it did not rise to the level of self-defense. It did not rise to the level of an armed attack. And the US said, yeah, but under Article 2, Paragraph 4 of the UN Charter, this was illegal aggression. And the ICJ said, too bad. These attacks do not rise to the level of warranting self-defense because they lack gravity or scale and effect. They are not armed attack. And you can see here, there's 15 justices on the ICJ. And so the United States lost each of these issues in quite a dramatic way. The ICJ ruled 12 against the US and 3 in favor of the US, that there was no collective self-defense. The United States said that what it was doing with Nicaragua, El Salvador, and Honduras, that was just self-defense. The court said that the US was in a breach of duty not to interfere in Nicaragua, that mining of Nicaraguan harbors constituted an unlawful attack against the country, and that America had unlawfully used force. So what the ICJ did was it ignored the low-level Nicaraguan attacks to undermine its neighbors. And in fact, there was a full-fledged war going on in El Salvador. Tens of thousands of people died. Nicaragua was funding the guerrilla insurgents. And the ICJ ignored that and then denied the right of self-defense to the US and its Central American allies. And so the ICJ held that the United States could not claim the right of self-defense, and that it should stop its blockade and respect the sovereignty and independence of Nicaragua. Now, if you're like me, you might be somewhat troubled by that. because this is mapping out the case. This is mapping out the case. And look at starting from the bottom row. This is what the ICJ is saying. The ICJ is saying that if on the left-hand side, that Nicaragua was funding rebels in neighboring countries, that was unlawful intervention, and that's a wrongful act in international law. Going one step up, if Nicaragua was providing weapons and logistical support and even dispatching small special forces into El Salvador, special forces units, armed bands into El Salvador, then that was the use of force. It was unlawful intervention. It was a wrongful act. But it still does not rise to the level of Article 51 on the right-hand side of this. Going one step further, the court said, even if there are frontier incidents like artillery duels, something that Korea knows, South Korea knows a lot about, if these are frontier incidents and even sending of regular or irregular forces, but these are small teams, relatively discrete fighting units, and it's not a full-fledged war, again, the ICJ said that's simply the use of force, it's intervention, and it's a wrongful act, but it's not an armed attack. None of those things are armed attack, and that's what you need for Article 51. Remember, Article 51 only authorizes force when you have an armed attack. And so all those things in the first three rows there do not constitute an armed attack. That's our gray zone. When North Korea is shelling South Korea illegally, the ICJ would say that's not an armed attack, and therefore South Korea is not entitled to self-defense. Now, self-defense is only permitted if you go up to the fourth line from the bottom or the second from the top, if the one country sends irregular forces with sufficient gravity, whatever that means. They have to be of sufficient gravity in order to trigger an armed attack and therefore allow the right of self-defense. So at the top, in the top row, everybody knows that if you send regular forces into a country, that's an armed attack. This is Nazi Germany invading Poland in 1939. And that's what the top line is saying. We got it. That's an armed attack, and the right of self-defense is allowed. And even if you have irregular forces, such as, say, North Korean SOF forces, and they have sufficient gravity, that also is an armed attack. But everything in the bottom three lines is not an armed attack, and therefore, there is no right of self-defense. Now, what does that tend to do? It licenses low-level attacks. It gives a pass to low-level attacks because there's not any risk of self-defense. All right, so I know I've been talking a while. I've got one other case. I won't cover it in detail because I think you have the idea. But the second case made things even worse. I think both of these cases are an abomination in international law because they actually license or enable gray zone attacks by tying the hands of democracies and stable countries to be unable to exercise the right of self-defense. So this case grew out of the Tinker War during the 1980s, just like the Nicaragua case was a 1980s case. And what happened is that during the Tinker War, some 500 ships were attacked by both Iran and Iraq, and both of them were indiscriminate. But Iran made it a policy, a particular policy, to create as much havoc as possible in the Persian Gulf in an effort to prevent the United States from intervening, and instead, that simply drew the US into the armed conflict. Both countries established exclusion zones, and they attacked ships both inside and outside the exclusion zones. Some 200 civilian mariners were killed over the course of about 8 years. Okay. All right, so there's a number of incidents that occurred in the tanker war that led to the case between Iran and the US. The first is that the United States reflagged Kuwaiti tankers, 11 oil tankers, only 11, but 11 oil tankers. The US reflagged them to protect them from attack, thinking that if they were Kuwaiti, then maybe Iran would feel free to attack, but it might be deterred if they were flagged under the US flag. In fact, the Bridgeton was struck by a cruise missile. The Bridgeton was struck by a mine, and the Sea Isle City was struck by a cruise missile. Iran had laid mines throughout the sea lanes, and again, causing damage for merchant shipping. So the United States realized that Iran was using these oil platforms as a surveillance platform to target civilian oil tankers. And so US forces attacked and destroyed these 2 oil platforms. These were derelict oil platforms, by the way. They were not being used to pump oil at the time. The United States also warned the people on board the oil platforms to get off and gave them like 30 minutes, and most of them got off. So the US destroyed these oil platforms. There were a number of other incidents, including the mining of a US warship, the Samuel B. Roberts, which you can see here, just like the USS Cole. And the mine that struck the Samuel B. Roberts was sequentially identical. Here's the Samuel B. Roberts. Sequentially, the mine was identical to those mines that were on an Iranian ship that was caught laying mines in the water, the Iran Ajar. The Iran Ajar was caught laying mines, and the numbers sequentially matched the mine that destroyed the Samuel B. Roberts. So there's a lot of other incidents over the course of these years, and as a result, the United States conducted Operation Praying Mantis, where it destroyed the 2 Iranian frigates in the Iranian Navy and destroyed some other patrol craft. It was the greatest naval battle since World War II. All right, let's get to the ICJ. So Iran, like Nicaragua, brought the United States to the ICJ. And the ICJ ruled against the United States. The key thing to remember is that the ICJ said that all of these attacks, the mining and the cruise missiles on US ships and the mining of US warship, was not an armed attack as set forth in Article 51. This is Nicaragua all over again. The court said that the United States said, wait, what we were doing when we attacked these oil platforms, we were just exercising our self-defense. And the ICJ said, no, these were not self-defense. This was not self-defense because what Iran was doing never amounted to an armed attack. Now, importantly, what's key is the ICJ, the United States would say, yeah, but look, you have all of these incidents over 8 years. And the ICJ said, you cannot take these incidents cumulatively. You can't just add up a bunch of small incidents and then say that that's an armed attack. This sounds familiar, doesn't it? For things that are going on in East Asia. You can't say, yeah, but there's this pressure campaign of coercion going on all the time. the ICJ would say, sorry, but that's not an armed attack. So in conclusion, the ICJ said that even the mining of a single warship may be sufficient to give rise to self-defense, but in this case it wasn't. Compare that with the definition of aggression by the General Assembly that said that aggression is an attack on the land, sea, or air forces, or marine or air fleets of another country. So the General Assembly actually got the definition of aggression correct. The ICJ did not. So, just like the Nicaragua case, the United States lost in a big way. 14-2, the US attacks against the Iran oil platforms were unlawful, and both of these operations that I mentioned, Praying Mantis and Nimble Archer. Nimble Archer was against the oil platforms. Praying Mantis was against the Iranian Navy. Both of these strikes were unlawful. All right, so if you bear with me for just a few more minutes, I think I can provide a graphic that explains these cases in a way that's helpful, and then we'll take questions. All right, in a nutshell, this is what the court is saying. The court is saying that self-defense is only authorized if there is a no-kidding armed attack, an armed attack that has gravity or scale and effects. And that if there's a use of force or an intervention or some small level of coercion, a mere frontier incident, those things are not armed attacks. And therefore, the injured state is not entitled to self-defense. What does this look like on the conflict spectrum? This is what it looks like. There might be, the ICJ is saying that there might be violations of Article 2.4 for unlawful use of force, but self-defense is only permitted if this unlawful use of force crosses this threshold of gravity or scale and effects. And that has created what people refer to as a gap between Article 2, Paragraph 4 and Article 51. There's all of this gray zone in here, which I have colored in red, in which all this illegal intervention, mining of oil tankers, shooting of missiles, all these things do not rise to the level of scale and effects, and therefore there is no right of self-defense. Now, I would suggest that this is actually how the law ought to be interpreted, which is once there is a violation of or an unlawful use of force, that triggers the right of self-defense immediately. This is the US view, by the way. This is the US view, and I'm not sure formally, but I suspect that the Korean Navy also, from the incidents that I've seen, also accepts this view. But the International Court of Justice is largely influenced by jurists in Europe, and so they don't accept this view. My position would be that this is a cleaner and a way to approach the problem, and it is also the way that strengthens deterrence, because then bad actors know that if they use unlawful force, they can be struck by self-defense. The response of self-defense is available immediately, and that there's none of this consideration for this gap where you allow some level of unlawful use of force to reach some type of threshold of gravity or scale and effects before self-defense is triggered. Okay, and that's all that I have for prepared remarks, and I'd be glad to take any sort of questions that anybody might have on this.
And thank you to all the participants and Professor Kraska. And CUBES will have the third Zealous Dialogue next month. And the topics is about China's new Coast Guard law with experts from several countries. So please ask any questions concerning the participation to us. The email address is as follows, like kims.or.kr. Thank you, everyone. Thank you, Professor.
Thank you. My pleasure. Everybody have a wonderful day.
You too. Thanks.